Imagine this. A mother passes away. She has 3 adult children. For years, her will says everything will be split equally. But just months before she dies, everything changes. One child gets the house, the bank accounts, and the entire estate. The other 2 get nothing. So the question becomes, was this really what the mother wanted? Or was something else going on? Today, we're breaking down a real decision from the Supreme Court of British Columbia, explained in simple terms. The family, names changed. Let's simplify the players. Margaret, the mother; Anna, daughter number 1, the one challenging the estate; Beth, daughter number 2, the one who received everything; Claire, daughter number 3, she stepped out early and isn't part of the case. Beth lived with Margaret in her final years and acted as her caregiver and power of attorney. What happened before the death? For nearly 20 years, Margaret's will said, "My estate goes equally to my 3 daughters." That changed several times, but the equal split always stayed, until the very end. Here's the timeline that raised red flags. Margaret developed serious health issues. She became physically dependent and used a wheelchair. Anna says Margaret became confused and childlike. Beth says Margaret was mentally sharp. Then, 3 months before Margaret died, a new will was signed. Anna and Claire were completely disinherited. Beth got everything Margaret put Beth's name on, the condominium, the bank accounts. Because of that, when Margaret died, almost nothing was left in the estate. Beth didn't even apply for probate because there was basically nothing to probate. The core problem. Anna believed her sister pressured or influenced their mother. The property transfers were not truly gifts. The estate was stripped empty on purpose. But here's the twist. Only the executor can normally sue on behalf of an estate. And Beth, the person who benefited, was the executor. So Anna went to court and said, "Let me sue on behalf of the estate, because the executor won't." The law that made this possible. British Columbia has a law that allows this in rare situations. It says, if an executor won't act and there's a conflict of interest, the court can let another beneficiary step in. But Anna had to prove 5 things. She had legal standing. She asked the executor to act. Proper notice was given. She was acting in good faith. Her claim was arguable, not hopeless. Beth's argument and why it failed. Beth argued, even if Anna wins and the property comes back into the estate, the final will still gives everything to me, so this lawsuit is pointless. The court rejected that. Why? Because you cannot challenge a will until probate is granted. Beth never applied for probate. That delay blocked Anna's legal rights. The judge said, you can't benefit from your own inaction to shut down someone else's claim. What about undue influence? Beth relied heavily on the lawyer who prepared the final will evidence, saying Margaret understood what she was doing. The judge agreed. This evidence is strong. But, and this is important, this was not a trial. At this stage, the court only asks, is there a reasonable case worth hearing? And the answer was yes. Why? Because a parent transferring property to a child raises a legal presumption. That child must prove it was a true gift. Margaret was vulnerable. Beth was in a position of power. That's enough to let the case proceed. The final decision. The court ruled, Anna can sue on behalf of the estate. She can try to recover the condo and bank funds. The case will move forward to a full hearing. Anna gets her legal costs, for now. Why this case matters. This decision is important because it shows executors aren't untouchable. Courts will intervene when there's a conflict of interest. Sudden estate changes and caregiver control. Legal scrutiny. You can't block justice by refusing probate. If you're dealing with estate disputes, caregiver influence, last-minute will changes. This case is a powerful reminder. Courts care about fairness, not just paperwork.